Have a very special presenter today, Long Beach's own Robert Baer. Thank you for joining us on this is our second session in our Know Your Power series, also known as the Citizens Media series that we are doing here at Long Beach Public Media. This is, for those that don't know, this is a pilot program. It's the first time that we are doing this series, and it's a series of 3. I recognize some names from our first session, which was called Know Your News, all about media literacy and news literacy skills that you can take as you sift through the deluge of information that you get every day. We know it's a lot. For those that weren't able to watch it, it is up on the Long Beach Public Media and also our KLB, or is it on the KLBP page? Sorry, Ashley. It's only on KLBP?
It's on both of them.
All right. So we were streaming it on the KLBP Facebook page, so you are welcome to go there and to view it. This is also streaming live on our Facebook page right now. Tell your friends, if they can't get into the Zoom room, to watch us live. Next Wednesday, we will be talking with journalist Kevin Flores, and it's the Know Your City, all about understanding how the city operates and how to attend a public meeting and how to hold your government accountable. So this whole series is really meant to just equip members of the general public with the basic fundamental understandings of your news, your rights, and your city. The eventual goal is that each of these sessions will be able to go more in depth on each one. Each one is kind of a track that we're envisioning. You can go more in depth. I'm sure you'll know that you'll see that the presentation today has there's a lot more rabbit holes that we could go down. So please give us your feedback. You're welcome to DM us or message us on Facebook, DM us on Instagram, on Twitter. I'm running the Twitter, Ashley's running the Instagram. And we'd love to hear your feedback on other topics you'd like to go more into in the future. So you're here at the start of this and we're expanding it as we go. So I'm going to pass it over to Ashley Aguirre. She is the president of Long Beach Public Media and is also helps run KLBP, the radio station. So take it away. Thanks again for coming, guys.
Thank you, Sarah. And thank you, everybody, for joining us.
Oh, you're on mute or your mic ain't working.
It's not. Can you hear me now?
It says that you're on, but I do not hear you.
How about now?
I do not hear you. I don't hear Robert either.
Oh, yeah, I hear both of you.
You can hear. It is me. Sorry.
Oh, okay. Hi, guys. I'm Ashley. I'm president of Long Beach Public Media. I'm really excited about this series, and I want to thank Sarah for all of her work in organizing and putting things together, and Robert Baer, who has put this presentation together for you guys. For those of you that don't know, Long Beach Public Media is actually the parent organization of KLBP, Long Beach Public Radio. So we oversee that and run the station. Robert Baer actually has a show on KLBP called Baer Law, of course, which I believe, Robert, originally you were going to call it Barely Legal.
I not only was going to, did for the first 4 episodes. So if you were listening back over a year ago, you would have heard Barely Legal. And then there was some theoretical pushback against that.
So his show is on Mondays and Thursdays at 10 a.m. This week we announced that we now have Democracy Now! As part of our weekly lineup. So he follows that up and he covers a variety of legal topics. He looks at the law all over the country, but also looks at how it affects us here locally and how it impacts our local rights. But I know, Robert, you can probably talk about yourself better than I can and tell us a little bit more about your background. So again, I just want to thank everybody for joining us. These workshops or sessions are actually produced free of cost. We're not charging anyone anything. Robert has graciously donated his time, but if you want to support this program, if you like this pilot program, please make a donation at Long Beach Public Media. We want to expand this program and offer a lot more and get some national speakers here to strengthen our community here in Long Beach. We are going to run this session a little bit different from the last one. If you joined us in the first one where we just had the Q&A after, because there was so much to run through with this one, Robert will take questions in between them. So if you need to clarify something or you need an example, feel free to drop a comment in the chat or, just say, hey, I need to ask a question, and you can unmute yourself and ask the question. So if at any point you feel like there's something that you didn't understand, let us know, because the whole point of this one is to really get you to understand your rights in this in this current climate. So I'm going to turn it over to Robert.
Thanks, Ashley. So, hello, everyone. My name is Robert Bear. I have, as Ashley said, a show that airs every Mondays and as of next week, Thursdays at 10 a.m. on KLBP. I'm a practicing attorney. I have a law office in Long Beach in the heart of downtown. I'm actually looking at the courthouse right now from the window of my office. So I practice locally and I do primarily family law and business law, but every now and then I get First Amendment cases. And whenever I can, even if I have to take a little bit of a discount on the retainer, I try to take those cases because that's really where that's where some of the most interesting law is, as you guys will see during this lecture. So, so the purpose of this presentation is it's made with the idea of having sort of protesters' rights in the forefront of my mind. Specifically, the May 31st protest I was present at and saw a lot of things at, and I'll actually be talking about the confluence of how some of the things that I actually witnessed at the protests intersect with both constitutional laws and political tactics by governmental entities, including the police force. And if nothing else, hopefully those of you listening will come away with this having a better understanding of what your constitutional rights are, but then also maybe additional knowledge as to why the governmental entities do the things that they do, sometimes to subvert those laws. And sometimes it's for nefarious reasons and sometimes it's not, but you'll at least know the why as well as the what. So the other thing I wanted to emphasize at the beginning is that the law, as you'll see, is in flux with the First Amendment all the time. And I'm going to give a specific example about halfway through this lecture of a area of the law where the highest courts in the land are almost perfectly evenly divided as to what the law should be. And some courts are saying it's going to be this, and some courts are saying it should not be that. And so if at any point in this discussion you're confused, you don't think I'm explaining something clearly enough, or you don't think that the law is clear enough, just post a question in the Q&A and I'll probably stop and answer it and try to expand and expound as well as I can. I may ultimately say, the law is kind of unsettled here, so there's arguments being made on both sides, and all I can tell you is what the arguments are, not necessarily how they're going to be resolved. And then finally, this is it's an opinion piece, so I'm going to give my opinions at times. I think that I do a good job of clarifying this is just my opinion, and there are times when I'm going to say this is what the law is, and my opinion is that the law is wrong, but my opinion, of course, is not the law. I'm just a guy in an office talking to you. So if I say that I think that a law is wrong, sure, you're aware of what my opinion is on the matter, but that doesn't mean that you now have carte blanche to go violate something that I say, despite the fact that I disagree with, is otherwise valid law. So with all of those caveats in place, I'm going to talk about the First Amendment for a little bit and how it intersects with protesters' rights and then just rights in general. And then I'm going to talk about the Fourth Amendment, which also obviously impacts protests and the protest movement. And the Fourth Amendment really deals with when you encounter the police and they either detain you or arrest you, what your rights and what your options are. And then just because I can't help myself, at the end of the First Amendment lecture, I have a few of the more interesting First Amendment cases, and I can't ever talk about the First Amendment without mentioning these specific cases. I'll try to go through them very quickly, but I promise, even if you're not interested in the law, these cases and the weird issues that they involved, that I should be able to hold your attention span, I think, because they're just weird and quirky areas of the First Amendment law. Okay, so with that, let me get started here. So we're talking about the First Amendment. We're talking about specifically free speech and arrest rights in the time of civil unrest. That's a very accurately titled slide there. And specifically, again, with regard to Long Beach, I want to talk about what happened on May 31st and those protests and what was legal and what isn't. And sometimes even things that are illegal, it doesn't really matter if it's illegal. These things happen anyway. So, I guess we're behind. Okay. So you see this, we're talking about constitutional rights here. All right, First Amendment. Congress shall make no law respecting the establishment of religion, prohibiting free exercise thereof, abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for redress of grievances. That's one sentence that actually covers 6 different things, or five different things if you count religion as one thing. And most people just call the First Amendment the free speech amendment, and certainly that's accurate. But as it relates to protesting, there's a whole bunch of different implications under the First Amendment, because it's free speech, sure, but it's freedom of the press. Some of you out there may have seen a CNN crew get arrested on live television during the George Floyd arrest, right? So the freedom of the press is obviously implicated by this amendment and by the protest movement. So that's being stressed right now, you might say. And the right of the people to peaceably assemble and to gather. So I'm going to talk about curfews and how those affect the law, but just gathering, even if you don't have a message, to peaceably assemble, and then to petition the government for a redress of grievances. And what could be the more current petition of government for redress of grievances than the Black Lives Matter movement and the George Floyd protests. So there's a lot going in here under the First Amendment that affects what's going on sort of with society in general and sort of in Long Beach in particular. So here are a list of those rights that I just went over. Religion, it's interesting. This obviously isn't a topic about religion, but you have the freedom to practice your own religion. That's one separate part of the First Amendment. And the freedom to have religion not imposed upon you. This would be the separation of church and state doctrine. So state of California cannot make Catholicism or whatever the official religion of the state, and you can practice whatever religion you want. So it's really 2 things, but speech, press, assembly, and petition. Okay. So I want to start off with good news here. And there's some, I don't know where this kind of stuff comes from on social media or whatever, but some people say that they feel like free speech is under attack, that you can't say anything anymore. At least as a legal matter, and certainly as it relates to the Supreme Court, there has never been more free speech allowed as a legal issue in the country's history ever, period, ever. And there are things that some people might consider to be areas where there should be less free speech. And the Supreme Court has said, no, as detestable as these ideas are, we're going to allow them. And that's part of free speech. So I cite 2 cases here of that. The first one is called Snyder v. Phelps. Now, you might not know that case by name, but you probably know the name Fred Phelps, and you almost certainly know the religion that he belongs to, the Westboro Baptist Church, because they're in the news all the time for going to the funerals of dead soldiers or other dead persons and holding up signs and protesting and saying reprehensible things, including, "We're glad that this soldier is dead." And so the family of one of these dead soldiers sued him for intentional infliction of emotional distress, or sued his church, because they said, "Hey, our child was killed in war, and you attempted, and you're protesting that and holding up these outrageous signs, and you've caused us emotional harm in doing that." And the signs themselves are, they're reprehensible. However, that goes up to the Supreme Court, and in an 8-1 decision, for as politically divided as the Supreme Court is, they certainly aren't divided on this issue. They held that the Westboro Baptist Church, as long as they're on public ground, they have the right to do that. And I don't think anybody would agree with the tactic, but the Supreme Court, at least, and I, as a personal opinion, I too think that it is consistent with the First Amendment that they be able to peacefully hold up signs that protest dead soldiers, or that say reprehensible things on them. So you've seen, it hasn't come up in the George Floyd protests as much in terms of the prohibitions on specific content of speech. But I'm just using this to show that the very limits of what you might think of as free speech, which would be holding up a sign that's intentionally emotionally harming the family members of somebody who died in war, that even that has been sanctified by the Supreme Court. And if that's not enough, the other case that I mentioned here, Alvarez, in that case, that was the so-called stolen valor cases. So if you guys out there do any YouTube searches for stolen valor, you'll see these videos where individuals who have never been a member of the armed forces, they dress up as if they are, and then they go around kind of pretending to be members of the armed forces, so that people say thank you for your service, or you want a free lunch or whatever. And then sometimes actual members of the armed forces will see that and call them out. And so a law was actually passed that made it illegal to falsely claim that you're a member of the armed forces. And the Supreme Court invalidated that law and basically said, if you want to lie about saying I served in the armed forces, even though you didn't, you might be guilty of some other crimes, most notably fraud if you're getting VA benefits or something from it, but you cannot be prosecuted for the law in question that just made the lie itself illegal. You cannot be prosecuted for that. So even something that most people would say, well, okay, it should be illegal to lie about being a soldier. And actually, I don't know that most people would say that, but a lot of people would say that. And enough people thought enough of it that a law was passed on it, but the Supreme Court said, no, no, no. So this isn't even just a political protest. These are things that, I'm showing you kind of the outliers of where free speech lies, and the Supreme Court has even sanctified that conduct. So to start this off on a note of optimism, free speech at the Supreme Court level is definitely alive and well, and the Supreme Court is allowing speech that even some people I think would say shouldn't be allowed. They're allowing that to exist as free speech. Okay. That being said, there are limits to the First Amendment, and the most common of those limits are the so-called time, place, and manner restrictions. I list and I go through the elements of what constitutes time, place, and manner restrictions in this. I think it's on the next slide, but I'll give you a broad example that I think will help everybody to understand at least what is meant by a time, place, and manner restriction. If California passed a law, and California has passed a law, that says you're not allowed to protest on the 405 freeway at 5 o'clock in the afternoon without a permit, I think most people would say like, well, okay, that's a sensible law. Now, if somebody wants to run out on the 405 freeway at 5 o'clock in the afternoon and they get arrested for doing so, and then they say, but wait a second, I was protesting whatever it is that I wanted to say. And so you can't arrest me for, I'm on public property, a freeway is a public place. So I have a First Amendment right to go out here and to say what I want. It's right there in the First Amendment. No, and the Supreme Court has said no, and that would be a time, place, and manner restriction. Now, it might be the case that you actually could, if you went through the governmental process, get a permit to protest on the 405 freeway at 5 o'clock. But again, you'd have to go through a governmental process that I'll describe in a second. But these time, place, and manner restrictions provide the clearest boundaries of the First Amendment. But this goes back to what I said at the beginning, which is those boundaries aren't entirely clear. So we'll talk about free speech zones in a second. And it's one thing to use what I think is an obvious example of somebody on the 405 freeway protesting without a permit, but there are much, much closer cases where it's like, is this the right restriction being done in the right way at the right time by the right governmental entity? And a lot of times I think the answer is no. So in terms of protest movements, this is probably the number one way that protest movements are curtailed, let's say, because unduly time, place, and manner restrictions are placed on those movements. All right, so I'll go through these quickly because I don't want this to be actually too dense, but if you're going to evaluate the legitimacy of a time, place, and manner restriction, you have to look at these four elements and they all have to be met. So the first one is that the regulation must be content neutral. And the comment that I made here is no banning conservative speakers on college campuses. Obviously, this would apply to liberal speakers as well, or any kind of political speakers, but I just specified conservative speakers because I wanted to illustrate the point. Your regulation has to be content neutral, so you can't single out a type of speech, conservative speech, say, and say, no, we're not going to allow that on our campus. We're restricting that type of speech on our campus. You cannot do that, and it applies the other way too. You can say liberal speech as well. It has to be narrowly tailored, so you can't just say, well, since we can't ban just conservative speech, we're just going to ban all speech on the campus. So no free speech on the campus at all, or no political protests on the campus. So you can't do that. Those laws are too broad, and the law in question has to be narrowly tailored. So a narrowly tailored law, would be to say, well, if you're going to protest, you got to get a permit first or something like that. The law has to serve a significant governmental interest. So I right here, no banning trite speech, which means like you couldn't ban speech that wasn't, for insignificant reasons. But I think the better example would be to say, to go back to the 405 freeway example, the government has a significant interest in ensuring that people are able to freely travel among the freeways. particularly during busy times of the day. And so therefore, and also in preserving the safety of the public, it's okay to have a law that bans speech on a freeway in the middle of rush hour, because that's both dangerous to the people trying to make the speech, but it also affects the people who are trying to travel on the freeways. And that law is content neutral, because it applies to all kinds of speech, and it's narrowly tailored because it would only apply, again, in this example, to a freeway. Okay. The law must also allow open alternatives for communication. So obviously, in the case of 405 freeway, it's like, well, you can go to a park and you can give your speech there. So that's your alternative. Okay, so the example that I give is the example I've been giving. You can't legally rush out on the 405 freeway. Now, some of you guys might be thinking, yeah, but I saw a whole bunch of that during the George Floyd protests. There were people all over the freeways, and including stopping traffic. You're right, there were. I'm just a lawyer talking about what's theoretically legal and illegal. The fact that some people in gross violation of the law ran out onto the freeway and the police sort of corralled them off and then didn't arrest them is a good thing, in the sense that you don't want the appearance of a police state action. And even if the police have the right to arrest somebody for marching out onto a freeway, sometimes the more sensible approach is to just get them off the freeway and maybe detain them temporarily to do that. But I don't think you need to actually arrest somebody, and you certainly don't need to prosecute anybody over that. So one of the tricks here is that I have to give legal advice to clients every day, and I have to describe during this lecture what the law is, and I've done that. Sometimes people don't care what the law is, and they just do what they're going to do anyway. I don't really have a comment on that, other than to say, stuff happens, and I was glad to see, and this is a personal opinion, that when the police moved those people off the freeway who were on the freeway, that they did so without actually arresting them. I was actually recording an episode of my show while streaming that a couple months ago when it happened, and it was sort of a live mic moment, I guess, because I didn't know what to say. I was watching this incredible event happen and hoping that nobody got hurt in the process. And then knowing that it's illegal and not wanting the police to run in there and start shooting pepper balls or something at these protesters who were, although they were violating the law, technically they were otherwise peaceful protesters. So anyway, so there is a difference between, what's legal and what's illegal, and what people just choose to do anyway. Okay, so with that, we get to permits. Now, this is one of those areas where I have clients and they come in and there's something that feels kind of distasteful about this in the abstract. And that is, if somebody comes in, and I've had this happen multiple times, and usually it applies to the Trump Golf Course. Trump Golf Course is in Palos Verdes. My office is in Long Beach. And people come in and they say, we want to go protest at the Trump Golf Course because that's sort of a symbol of the Trump administration. And I'll say, no problem. We just got to call up Ranchos Palos Verdes and get a permit and go through the permit process. And I've had it happen more than once where people are like, whoa. I have to get a permit. We got to go talk to the government. I have a First Amendment right, buddy, to just go and to protest in a public area. Why do I have to ask permission to do that? Well, because the Supreme Court said that it's okay for governmental entities to make you do that. That's the incredibly reductive answer. The theoretical answer is that the court has determined that sometimes, particularly times when a protest gets big enough, there are logistical considerations and liability considerations that create a compelling governmental interest that would allow a jurisdiction to require a permit. So remember, when we talk about time, place, and manner restrictions, one of the requirements is that the law has to be narrowly tailored. So if you were to walk into the city of Long Beach and say, we've got 100,000 people and they're going to be on Pine and Broadway on Saturday, courts have determined that the city of Long Beach would be within its rights to say, well, make sure you've got a bunch of porta potties out there then, because we don't want to have to clean up the mess if people are urinating on the street or whatever, because you've got 100,000 people out there. And make sure you've got liability insurance to cover any harm that might befall the protesters, because the city doesn't want to be responsible if while protesting somebody falls and breaks their leg on something. And make sure that it's only being done during these hours, because 100,000 people make a lot of noise and we don't want them going into Bixby Knolls or something like that and waking up all the neighbors. So those kinds of restrictions and limitations and regulations have been sanctified by courts at almost every single level. And having said that, I will say that the protests that most people are thinking of, which are, say, smaller in nature, and actually the permitting process, in my experience, it's not actually that difficult. There might be a couple pages of permits, and as long as the protest is within a certain size, there's not a lot that's actually required. I will also say, though, without naming names, that people have consulted with my office, and the protest got large enough that maybe there would have been a requirement to take out liability insurance. And the entities consulting with me were so offended by that and definitely did not want to pay out of pocket for protest costs that they just had the protest anyway. And I would turn on my news on Saturday or whatever, and it would be like, hey, here's a protest at Trump Golf Course. And I thought, wait, these are the guys who were just in my office a week ago. They didn't get a permit. They just went out there and protested anyway. Again, just like...
There is someone here who has a question about that.
Okay, go. I can't actually see the questions as they come in, so I appreciate you interrupting me, but go ahead and ask the question.
It's from Katie, Kate Herzog, who says, but the permit won't require the protesters to pay for police?
No.
Okay.
No, no, but it does put the city on notice that if the protest is big enough, that they might have to have extra police available. And that's one of the arguments used by governmental entities in justifying the requirements of a permit in a permit application process. The city will say, if there's actually going to be 100,000 people, we need to have people available for overtime and put people on notice. But in terms of actually offlaying those costs onto the protesters, as a practical matter, I'm not aware of that happening. Certainly, most of what I've dealt with is, again, about the Trump Golf Course, because that's just such a beacon of protest activity. And so you're dealing with the city of Palos Verdes or Rancho Palos Verdes. And no, they haven't asked for anything like that. But that's not to say that you can't be required to pay out of pocket. Again, for liability insurance is probably the most common out of pocket cost. And porta potties, again, or other infrastructure like that, again, if the protest is big enough, those are other things that the government has allowed for. So this is one of those areas where it's like there's the law as it's written, and then there's just what people do. I'm telling you that the law that is written is that you need to get a protest, legally speaking, to be able to do a lot of the protests that people are thinking of, including, by the way, all the George Floyd protests, all those random protests, including the May 31st protests that just sprouted up. Theoretically, those were illegal protests in the sense that none of them had permits, and all of them started basically on social media. And we're going to talk about the benefits and the good and the bad of being organized as a group in a second. But theoretically, if that was let's say it was like a Planned Parenthood protest. Planned Parenthood is a nationally recognized organization with a headquarters and a CEO and all that. Theoretically, the city of Long Beach could have sued Planned Parenthood for having that protest without a permit. But when you're talking about the George Floyd protests, and they're technically Black Lives Matter protests, but Black Lives Matter is itself kind of a disparate group, and it's not as well organized and doesn't have the infrastructure that some of these other nonprofit entities do. It's really hard to go after them being the Black Lives Matter protests. So my legal advice is, well, if you want to follow the law, you have to get a permit. My experience on the ground and in the trenches is that a lot of times people don't get permits, and there's really no consequence to them not getting the permit. So that's a good lawyer's contradiction for you.
Can they act, or have you run into any cases where a permit has actually been denied, and can they actually refuse to grant the permit if it's potentially going to cost the city a lot of money for police protection to run it?
No. And in fact, there was a famous case, we're just talking about like banning conservative speech on campus, where the conservative speaker, Ben Shapiro, was going to Berkeley, talk about a clash of ideals. This conservative iconoclast wanted to give a political speech at Berkeley, and there were enough threats made against him in doing that I don't know if it was the city of Berkeley or the University of Berkeley had to invoke a cost of like $1 million to put the infrastructure in place to ensure that it was safe for him to do so. There's all these police and all that. he obviously didn't have to pay for that, and his entity didn't have to pay for that. Ultimately, I suppose the taxpayers paid for him to give that speech. So I don't want to ever say never, but I'm not aware of the police attempting to pass on the cost of just the police presence to the protest. Now, I can, being an attorney, speculate about things that could happen during a protest that would create liability for the protesting organization. So I'll just use Planned Parenthood because, again, it's an organization that has a lot of built-in infrastructure. If they had a protest and then during that protest, they actually said, like, you know what we need to do? We need to go to every conservative Republican office in the city and, break some windows. Then obviously there could be liability imposed for them kind of rabble rousing that way and advocating for the creation of violence. But just as a preventative measure, which is really what this question is about, can costs be deferred onto police for just being there? I don't think that that's the case. All right. Oh, good. And it's actually perfect for this this slide. So one of the interesting things, and I don't want, well, hold on a second. Let me check for time. Okay. In the George Floyd protest, and this has been used as sort of a wedge issue a lot, there are people who engaged in looting and violent conduct during that protest. And it's very unclear if those actions were actually politically motivated or if they were just sort of opportunists. The disadvantage of being an organized entity is that sometimes you'll get, I've referred to them in the site as rabble rousers. So somebody who just throws a brick through a window, lights fire to a building, including the one that was burned down in Long Beach. And they're just doing that as just a crime of opportunity, let's call it. And yet when that's shown on the news, because it's happening in the context of a protest that was also happening, that person who let's use Long Beach, a suit store was burned down in Long Beach. The person who did that remains unidentified. And yet some entities out there have associated that person with Black Lives Matter. You don't know that that's true. And it's the same thing with the looters. You don't know that that's true. So the disadvantage, though, is that when you don't have a protest that's so organized, any kind of even outly acts of violence can be easily associated with that protest because it's so disparate. Bad acts get associated with something that was actually peaceful in the case of Long Beach. The good thing, though, is that if an entity, let's say the city of Long Beach, wanted to actually sue for the violence that happened on May 31st, it's really hard to do. Who do you go after? It's not clear at all that the bad actors were part of the Black Lives Matter movement. They probably weren't. So the disparate nature of the movement is that it's hard to target it as a singular entity. But the disadvantage is, because it's hard to target as a singular entity, rogue agents who are not acting in that unit or that entity often get associated with it. So it's sort of weird how that works out sometimes. It's there's advantages or disadvantages, say, of being organized. I don't want to belabor the point too much. Okay, free speech zone. So I'm going to just touch on this very, very quickly. They go back to the 1940s. They really got ramped up during the Bush administration, the George W. Bush administration. So obviously the Iraq war is raging. And in 2004, he was running for office or running for re-election. And there were a lot of people out there who wanted to protest the war and protest the Bush administration. And he has to be out in public because he's trying to rabble up his base to get reelected. So it's not like he could just stay in the White House or something, but he did not want to have to deal with all these protesters either. So a function of the law that had been sanctified by the Supreme Court in the 1940s, these free speech zones, were widely expanded so that, like, 3 blocks away from where the Bush speech was actually being given or something like that, there would be, these pictures are pretty hilarious, a little square designated for, like, this is where you can do your free speech, where it's nice and safe and nobody will notice you and the media won't see you and anything like that. These really, I just have such a visceral reaction, even though I said that it's funny. It's sort of funny in a sad way because it's so offensive and wrong that the way that free speech zones have been handled has been expanded to significantly curtail free speech in the way that was originally intended with a free speech zone. Don't get me wrong, I don't like speech being interrupted either, but there should be an opportunity if there's going to be a speech in one place for either a counter speech to happen in that exact same place, or for protests to be done within the general vicinity of that place. I mean, really part and parcel to that place, so that people can get the full picture. But like by marking a square 3 blocks away where nobody's going to see anything, and saying this is the place where your free speech rights will be recognized, that goes too far in my opinion. The Supreme Court has validated free speech zones, so I don't want to say that free speech zones are illegal, but this recent expansion of free speech zones has not got to the Supreme Court level, and I hope it does. And one thing, again, by those Supreme Court cases that I cited to you earlier, the Supreme Court's been pretty good about free speech, and the justices, whether conservative or liberal, seem to come to consensus on that. And I think in this case, they would come to a consensus that would restrict free speech zones. And when I say restrict, I mean restrict laws that create free speech zones, thereby expanding the right to free speech, particularly political speech, which is a speech that historically has gotten the most protection. It's not like you're standing in a free speech zone, advertising Coca-Cola. You're doing that because you're making a political point, and that is the area of the First Amendment and the free speech clause of the First Amendment that the court has given the most amount of deference to. All right, unlawful assembly. So this is this kind of gets back to the question that was asked a little bit ago. So an unlawful assembly is defined as 2 or more people getting together for an unlawful purpose. The California Supreme Court uses the United States Supreme Court standard, which is called the Brandenburg test. Brandenburg test is the Ku Klux Klan came to, or wanted to come to, a city in Ohio, and this was in the 1960s. And the city said, you can't have your speech here, you can't have your event here. I think it was actually a parade or something, because your mere presence here is going to cause violence. And the Supreme Court, in a 9-0 ruling that is still good law, said that the city could not do that. They could not preemptively prevent the KKK from holding an event to advocate for their cause in that town. Now, there's an exception to that, which is the imminent lawless violence test, and that is to say, if there is the potential for imminent lawless violence, or I should say the likelihood of imminent lawless violence, then governmental entities are empowered to declare an unlawful assembly and to act to break up that assembly. So if the KKK showed up and then they're, pointing to African Americans in the crowd or something like that and saying, you know what, we should get you guys, or something like that, then the police would be empowered to actually come in and break up that protest. But just the Supreme Court said it was a bridge too far, though, to say, before the event had even happened, that just because it's you, the KKK, and you have this reputation, we're going to unilaterally prevent you from coming to the city to give any sort of speech or talk. And it does get to an interesting issue, because recently, in the last 4 years, there's been this disturbing reemergence of like Nazis, weirdly, in America. And some people are saying, if, say, a Nazi wanted to come to a town and give a speech, that Nazi ideology is inherently violent, and it calls for violence, it calls for the extermination of groups of people. So isn't that the mere presence of a Nazi in, say, the city of Long Beach, wouldn't that create the potential for imminent lawless violence? No courts have weighed in on that yet, and I thought that we figured out that Nazis were bad like 70 years ago, but maybe not. It's sort of new fertile ground now that it might be the case that a test of the imminent lawless violence standard will be sort of reemerging if, I can't even believe I'm saying this stuff out loud sometimes, Nazis want to come to a locality and actually protest in that locality. So the Brandenburg test said that you can't preemptively prevent somebody from coming in. Well, maybe that needs to be re-examined in the context of Nazis, which have an inherently violent ideology, wanting to give political dialogue somewhere. Okay, so when an unlawful assembly is declared, and by the way, one was declared on the May 31st protest in Long Beach, that empowers the government to, specifically the police, to break up that assembly. And it was very, very interesting because I was on the corner of Pine and Broadway during the sunset hours of May 31st. And the police were standing there declaring out loud, this has been declared an unlawful assembly. And I'm looking around at a whole bunch of people who are doing nothing other than chanting and protesting, and there's certainly no violence. And I'm thinking, oh, you probably are declaring this unlawful because nobody ever got a permit. Well, then that's kind of a technicality. I really hope you guys don't move in and try to break this up because nobody's doing anything wrong right now. And they didn't move in to break anything up, happily, although one disturbing picture emerged of an officer maybe pointing what was it, a paint, something at a child. I forgot what it was, like a beanbag gun or something. So in any event, that assembly was technically declared unlawful. I believe that was done. This is me speculating a little bit, but I believe it was preemptively declared unlawful so that at any point the police would have been empowered to break it up if they wanted to, on the pretext of, well, this was an unlawful assembly. I don't think that's legitimate. And for those of you, if you're listening to this, it's a thing to keep an eye on. And unlawful, it's one thing to declare something an unlawful assembly because it's a KKK rally and you're worried about violence breaking out. It's another thing to have a George Floyd protest that is otherwise completely peaceful, and you have the police preemptively declaring it an unlawful assembly, probably because there was no permit issued for it, and then using that as a pretext to break up what is otherwise a perfectly legitimate exercise of free speech. So in terms of things to keep an eye on, I think that's one of them. I think it's a big one. So.
I actually have a question for you here on this in particular. Are there any limitations in place for law enforcement as to what force can and can't be used to break up a quote unlawful assembly? Because we've seen such violent and disturbing images just nationwide, specifically in Portland, Oregon, people getting tear gassed almost nightly there for the last 60 plus days. Are there limitations to what force they can use? Like, I'm curious if there have been any court rulings or any cases brought forth that examine that.
Yeah, absolutely. So 2 examples I can think of. One was a press, I think it was a member of the press, was actually shot by a rubber bullet in Long Beach, I think. And the officer who shot that rubber bullet was fired and should have been fired. And I think he like bragged about shooting it, or maybe he showed blood on his hands. Or there were a couple of things that the police did that didn't really reflect well on the police in Long Beach. But the answer to your question is the violence used to break up the protest, or really to detain anybody in any circumstance, we'll talk about this more when you get to the Fourth Amendment, it needs to be proportional to the threat posed. So the other specific example I wanted to give you was, and you brought up Portland. In Portland, a restraining order was actually given by a federal judge restricting the use of tear gas in that jurisdiction. And so the state police had to stop using tear gas because it was deemed to be a non-proportional response to what was almost universally a peaceful protest. The difficulty came then when the president unleashed federal troops into Portland. And then it was like, well, okay, your restraining order covers the city of Portland police, or maybe even the state police, but it doesn't cover these federal guys. So maybe they can shoot tear gas. But the legal standard is it needs to be proportional. So you're not able to just, start wading into people with billy clubs because you want to break up a protest. And that does create kind of a tricky business for the police. And if you want to break up a protest and you're outnumbered and you want to detain people, but you don't want to be too violent about it, you're not legally allowed to be too violent about it, sometimes that can be kind of hard. Ideally, the police will just sequester people, the real rabble-rousers, they'll sequester off to the side, maybe they'll put zip ties on their hands or something like that, and then they'll usually just cut them loose without formally arresting them or formally charging them. Sometimes that's less practical, and sometimes things just get out of control. I remember I think it was Buffalo had a couple bad incidents where people were just being basically beaten up by the police. And again, they're otherwise peaceful protesters. This is not somebody who's holding a brick and trying to cause trouble. So your question is, are there standards? There absolutely are standards. And sometimes the police violate those standards, and that gets into Maybe we should have a lecture about this, about qualified immunity and a whole bunch of other things. But I think the more interesting argument is about what should happen when the police violate those standards, because the standards are definitely there and the police are violating those standards at times, and in my opinion, too often time without consequence. Okay, curfews. When are they legal? Well, they're legal for natural disasters, public health crises like the pandemic that we're in, and ongoing civil disturbances. So this is another one where a lot of these things, it's like, because the government is enacting them and the government kind of has a conflict of interest in both enacting a curfew and seemingly having it go on forever. Like maybe the government should just have curfews all the time because that maximizes the power of the government. Well, as a practical matter, that hasn't happily happened. And when there was a curfew in Long Beach, it lasted about a week and then it was over, and then that was the end of it. There was an interesting territorial dispute where Long Beach had like a 6 p.m. curfew, and then Los Angeles County had a 10 p.m. curfew, and nobody knew when to go inside. And I had to figure out when to order my Postmates for dinner because all the businesses were about to close, and I didn't know if it was going to be 6 p.m. or 10 p.m. was the curfew. But again, this is one of those things that it just viscerally, it annoys me a little bit that the government's going to kind of dictate when people can be in their houses. You always kind of want to watch out for police state actions. However, despite that sort of gut instinct that I have to say that as a practical matter, and certainly as it relates to Long Beach and Los Angeles, I haven't seen anything that I would consider to be egregious violations of the law where curfews are extended for months on end, or people are going door to door or going into parks and rounding up people and just kind of detaining them en masse. Like, I haven't seen any of that, but the existence of a curfew during civil unrest that's a legitimate use of governmental power, as said by the Supreme Court. So it's theoretically possible that if you're at an otherwise completely peaceful protest, that if it happens during a curfew, that protest could be broken up and you could be detained for not disassembling when the police order you to disassemble, even if you're otherwise peaceful. And I know that that's frustrating. I'm just kind of telling you what the law is. Okay, filming the police. Now we get to the good stuff. So in California, I have a fairly brazen attitude towards this, and I say go for it. Here's my rules for interacting with the police when you're going to film them. Film them at will. Do it conspicuously. And when I say conspicuously, I mean don't hide your camera, because there is California is a one-party consent state when it comes to eavesdropping, and that would apply to police as well. So if you're secretly recording conversations with police, it depends on the context, but that technically that would be considered eavesdropping. I also use a pretty outrageous example here, like filming an officer using the restroom. You obviously can't do that. That's sort of common sense. But what everybody is thinking of, which is you're watching somebody get arrested, like George Floyd, and you pull out your cell phone to videotape that. You can do that at will. You should do that at will. The only rule besides the rule about being conspicuous is stay far enough away from the police that they cannot validly accuse you of interfering with their investigation. Sometimes the police will do things like they'll have other officers attempt to stand in front of your camera. That's annoying and it's unethical in my opinion, but obviously you can't move that officer out of the way so you can get a better angle on it. You need to not touch the police or really in any way interact with them. I also sometimes see people, like yelling at the police from the sidelines. I mean, I would encourage people to be civil because the court of public opinion matters on these things. And one of the reasons the George Floyd protest took off the way that they did is because that was such an outrageous event. Part of the reason it was outrageous was because what was captured on video. So, not a whole lot is gained if you're just, yelling at the police or calling them pejorative names or anything like that. Just the service that you're providing is just filming the incident to begin with. So do it as much as you want, just do it conspicuously and do it at a safe enough distance that they can't reasonably accuse you of interfering with their investigation. Okay. Man. Yeah. I'm going to talk about one of these 5 awesome cases that I brought up because of time purposes. So that one awesome case is the Moores v. Frederick Bong Hits for Jesus case. And because it's the picture that was used. In that case, a bunch of high school kids decide, this is exactly something I would have done in high school too. The Olympic torch for the 2002 Salt Lake City Olympics was going through their town. And so the school thought it'd be a great event for the kids to go outside and to watch the torch come through town. Like, hey, history in the making. And these ne'er-do-wells here, seen in this picture, decided to make this giant sign that says "Bong hits for Jesus," and then to hold that up while the torch came through. So when all the media showed the school kids cheering on the torch, it would also include this quasi endorsement of then illegal drug activity. So the students got suspended, and on the one hand, I don't like this. On the other hand, as the father of children, I kind of love it. The father of one of the kids sued, or the parents of one of the kids sued, and the school attempted to try to negotiate a like a 1-day suspension or something like that. It would have been something fairly benign. And the father was like, no, we're going to court. We're going to the appellate court. We're going to the United States Supreme Court over, a 1-day suspension for this. And the case goes up to the United States Supreme Court, 2 years of litigation, probably $100,000 in legal fees over this, a 1-day suspension. And so when it gets to the United States Supreme Court, in an incredibly divided 5-4 opinion, where 4 people thought it was free speech, the majority said that it's not free speech. However, there's a qualifier there. The majority said this specific example is not free speech, and they've kind of couched it on the phrase being nonsensical. We don't even know what these kids are advocating. Is this a political statement? Is it a religious statement? Is it a recreational drug use endorsement? We don't know. But 2 of the justices, who are both still on the bench, said that if this had actually been a political statement, if it had actually just said legalize medical marijuana, Jesus would legalize medical marijuana, that those 2 justices would have changed their vote, and it would have gone to a 6-3 decision the other way. So the case is hilarious, because when you read the Supreme Court opinion, you're reading the Supreme Court going to an in-depth discussion about bong hits for Jesus. And it's just funny to see the Supreme Court, this austere body of old intellectual heavyweights, talking about such a cavalier topic. But also, it's also fun to consider the fact that a similar case could come up in the future that's just slightly more political in the content of the speech being advocated, and the Supreme Court would change its opinion then, and actually that would have been free speech. So, and actually, I should, even though I said I wouldn't, this Tinker versus Des Moines case, that one's really important. Students wore armbands to protest the Vietnam War, and they engaged in a walkout, and the Supreme Court said that was valid free speech, and the school could not punish them for doing that. And that was really important, because that case sort of tested the bounds of school providing rules for children against those children's free speech rights. So those are the 2 worth remembering there. The rest of those cases don't have anything to do with this topic. They're just really fun. If this is online, you can look them up. In Cohen v. California, a guy wore a jacket into a courthouse that said "blank the draft," and the blank was a 4-letter word. And the Supreme Court actually said that's perfectly valid free speech. And the other 2 you don't need to know about. So, okay. So now we'll go into the Fourth Amendment. All right, Fourth Amendment, not going to read the whole thing. This is your right to be protected from illegal searches and seizures. And a search is obviously a search of the contents of your person, and a seizure is you being detained by police. So that's the bulk of what I'm going to focus on here. And as it relates to protests, the real emphasis is on if you're detained, or if you encounter a police officer while you're protesting, what are your rights? What are the officer's rights? And if you end up getting detained or arrested, what can they take from you? So let's talk first about what is unreasonable. The Supreme Court has said, at least as it comes to searches, you have a reasonable expectation of privacy. So what that means is the police cannot peer through your blinds without a warrant, or hold a glass up the door to hear you in your house because you think you're alone in your house. You think that's private conduct. However, if you're on a cell phone in a park talking about a murder that you committed, and a cop walks by and hears you, you can't say, hey, bud, I have a right to privacy here, because you're in a park talking on a cell phone. So you can't do that. And if they hear that, they can arrest you or use that information against you later on in court about it. So this is fairly obvious stuff. One thing that I want to note, and I note this every time I get the opportunity to, is that this also applies to filming in public. So I just did this whole thing about you can film the police all you want. You can also film other people as much as you want, as long as there's no reasonable expectation of privacy. And that applies whether the person you're filming is on public land, like a park or on a freeway, or if they're in a private commercial business, a business that is a place of public accommodation, they call them. So Lowe's is technically a private business, but if you go in there and you start filming people in Lowe's, sure, you're being a weirdo, but you're not actually breaking any laws. So sometimes people say it's illegal to film me, or this is private property or whatever. Lowe's can kick you out of there because it's private property, but you can't be arrested for violating somebody's privacy rights because you're in a Lowe's. It's 100,000 square feet and there's 1,500 people here. So there's no expectation of privacy. So that's what the standard is there. Actually, I wanted to ask you real quick because I changed from First Amendment to Fourth Amendment. Are there any other questions or anything about the First Amendment?
I haven't seen any. If anybody does or missed anything, please drop them in the chat. But I think we got through them.
Okay, good. I'm trying to race that. Typical lawyer, I thought I might not have enough material, and now it looks like it's too much. So, okay, so now I want to talk about seizures. So we talked about searches and the reasonable expectation of privacy. So now seizures. There are 4, but really 3 possible states that you can be in while encountering a police officer. The first one is just having a chat. You're in the park talking on the phone, cop comes up to you and says, "Hey, what are you doing here?" If you talk to him, that's on you. You're not detained, you're free to go. You're not arrested, certainly. This is just a cop walking up to you and having a conversation like 2 guys talking in a coffee shop or something. Then the second standard, which is the one that I hate and that is basically illegal, and I'm loath to mention it here, except I technically have to be complete as an attorney, is the stop and frisk standard. And that allowed temporarily, and it was used most prevalently in New York. It allowed police to just stop people in so-called high crime areas and to just kind of pat them down and to make sure they're okay. Of all the things I mentioned here, probably the one that offends me the most in terms of the police stateness of its applicability and also the blatant racist way that it was actually implemented. And every judge that looked at that had significant problems with it, and it was eventually done away with. And the mayor of New York, who had endorsed it at the time, Bloomberg, who just ran for president as a Democrat, gave an incomprehensibly incompetent answer when asked about it during the Democrat debates, and it more or less, along with his answers about sexual harassment suits, it's kind of sunk his candidacy for president, and as well it should have. It's an outrageous policy and it shouldn't be around, and it's not around in this jurisdiction or jurisdictions around us. So you don't really have to worry about it around here, but I have to mention it because it's technically it's a form of a police encounter that you could have. The next encounter would be detainment. This is you getting pulled over by a cop and you see the lights pop. You're certainly not free to leave the way you are if an officer just walks up to you in a park, but you're not really under arrest either. So these are called Terry stops. The officer has to have what we call reasonable suspicion that a crime has been committed. So that's usually a tail light being out or registration not being valid or something like that. And they can ask you about that and they can detain you for what is a reasonable amount of time. What does that mean? Informally, it means about 20 minutes, but there's no set number. And then they either have to cite you, arrest you, or just let you go. And this is why the ACLU all the time is banging the drum on asking police when you encounter them, am I being detained? Am I being detained? And it's because the ACLU does that. It's become kind of a cliche at this point, but they do that because they want the officer to put you on notice that you're being detained so you can start the clock of reasonability. And this especially applies, I'll mention it in a second, about with dog searches. If the police smell marijuana in your car or something and they think that you got pot and they want to call in a dog unit, sometimes it takes so long for that unit to get out there that the reasonableness of the stop becomes excessive and charges have been thrown out on that basis. Can't keep somebody pulled over the side of the road for an hour without arresting them or charging them or letting them go with something just because you can't get a canine unit out there soon enough. So that's detainment. And then, arrest is being arrested. And at that point, you have to be read your Miranda rights and you can be searched incident to arrest, which we'll talk about in a second. I should also mention during the detainment process with the so-called Terry stops when you're pulled over, you don't have to be told your Miranda rights yet. And this comes up most commonly in DUI cases. The officer pulls you over and says, "Hey, I pulled you over because your back tail light is out. You had anything to drink tonight?" If you then say, "Oh, well, actually, officer, I had a couple beers," the officer's not violating your right to remain silent by asking you that question, and he's not violating your right to remain silent by not reading you your Miranda rights. You're detained because you're pulled over, but you're not arrested yet, and your right to have those rights told to you does not kick in until you're actually arrested. How do you know when you're arrested? Well, handcuffs are a pretty good indication. Put your hands behind your back is a pretty good indication, and the officer telling you you've been arrested is a pretty good indication. So that's how you know when you've been arrested. Okay. If you're protesting and you get arrested, or somebody around you gets arrested, having it on video is very, very nice. That's very helpful. Not doing anything illegal is even better. And I got to say, during these George Floyd protests, the best thing for me is that a lot of the protest activity has actually reinforced the underlying premise of the protest to begin with. By that, I mean, the protests are about systemic racism and overbearing police activity. And what have we seen during the protests? Systemic racism and overbearing police activity in terms of how police have reacted to the protests and in breaking them up. And there's a tremendous irony when you have 10,000 people protesting police abuses, and in breaking up or dealing with those protests, the police are committing police abuses. It's like, oh, thanks for making the point, guys. This is what we're protesting about. And the reason that we're seeing all that is because everybody's got a cell phone now and everybody is filming it. So if you're being arrested or you see somebody being arrested, yeah, having the video is so important. It's so important. And by the way, there's been a complete 180 on this, because when I was a kid, the city of London put up all these CCTV cameras all over the place, and everybody thought that was very police state-like. It was like, man, I don't like having cameras on every public corner in the city. Turns out it's the exact opposite, and that's why everybody, including me, is advocating for badge cams now on officers, because that chronicles the events. Like there should just be cameras everywhere all the time for almost all public activity, not private activity, public activity, because that's how people keep each other in check, and that's especially how you keep police in check, is by having footage. And sometimes officers' cameras, whether it's intentionally or not, don't work, and so it's nice to have backup filming from a security camera or somebody's cell phone camera. Okay, and the last thing on this is remaining silent is really important. I'll talk about a video in a second, but in my experience, nobody has ever talked themselves out of being arrested ever. And so even though it might feel like there's an injustice being happening, and maybe there is when you're being arrested or when somebody with you is being arrested, you're doing yourself no favors by attempting to talk yourself out of it. And you could be hurting yourself if you end up admitting to conduct, or in attempting to try to explain away some conduct, you end up implicating yourself in other conduct. Just shut up. Just shut up and let your attorney deal with it. You're definitely getting arrested if you are arrested, and you're not talking yourself out of being arrested. So it sucks. It's going to suck to have to go to jail that night, but your defense attorney will thank you when the police report comes back and they don't have anything on you with regard to things that you said after being arrested. So every single defense attorney that I've ever met ever will tell you the same thing. It's ubiquitously known by us, and it's a very common thing that attorneys say, and it's 100% true. Just don't talk. Okay. I allow myself one exception, and it's only because I've actually seen it work. The exception is if you're actually innocent, somebody's actually filming, and the police could have exonerating evidence in that moment by just looking at somebody's cell phone. It's okay for you to tell the police, see John over there, he recorded the whole thing, go watch his cell phone, and then they can do that. Here's something that's important though. The police are not allowed to confiscate that cell phone, not without a warrant. They can't do it. You can voluntarily give them the footage, but they can't just take it from you without a warrant. So that's important as well. All right, this video that I talk about here, if you, this guy speaks better about this issue and for 45 minutes on it than I ever could. So just do a YouTube search for "Don't Talk to Cops." And this guy goes through 8 incredibly compelling reasons, and he's an incredibly compelling speaker while doing it, about why you shouldn't talk to the police. And by the end of it, you will be convinced to not talk to the police. And I don't need to say anything more, because everything that I could cover on this topic, he would cover. So that video will tell you everything you've ever wanted to know, and a lot of things you didn't know that you wanted to know about why you shouldn't talk to police. So
Hey, Robert, we had a question kind of on that topic quick. Judy was asking, what exactly do you say when an officer comes up to you and loudly shouts, "What are you doing?" And I seconded that question because you were saying don't talk to cops after you don't say anything after you've been arrested. But what about before, like when you're being detained?
Mm-hmm.
How much
Well,
you legally have to say then?
yeah, I'll give you the lawyer's answer. It depends. Well, what is it that you were actually doing? If you're innocently protesting, you're just standing there protesting, and the officer says, "What are you doing?" You can say, "I'm protesting." It's a perfectly valid explanation. But usually, if an officer runs up to you, they're trying to implicate you for something else, and it could be that the officer saw something out of the corner of his eye about, it's like somebody throws something, and he looks and he can't see who it was, and he sees a group of people, and then he runs up to you. He's like, "What are you doing? Who threw that?" If that happened, and let's say that's the example, that somebody threw something and runs somebody, who threw that, and that's what the officer says, I would not volunteer any information at all. And just say, I don't have anything to say about that. It might be the case that the officer immediately suspects you of doing that, but again, you could be implicating yourself by saying, like, "Oh, I saw the whole thing happen. My buddy Jimmy over here, he was the one who actually threw the thing." And now, obviously, nobody's going to do that either. But you also wouldn't want to lie and say nobody threw anything, and then a video comes down and shows somebody did throw something, and now it looks like you're kind of in on this conspiracy to commit a violent act because you lied to what an officer said. Not that that's illegal, but the implication of which is that you're sort of associated with the rabble rousing that I was talking about. So if you, I should have mentioned this before, but let me say it unequivocally here. The United States Supreme Court, and this is a standard in every single courthouse in the country, has said, if you remain silent, the very fact that you remain silent can never be used against you ever. A prosecutor cannot tell the jury, they asked him if he did it, and he didn't say anything. They can't do that. They can't even say, the prosecutor is barred from even raising that as an issue with the jury because it taints the jury pool. It cannot be used against you that you just shut up. And that's why every attorney tells you to do it. So the example that you give, that's just an officer coming up to you. I would say it depends on the circumstance because you haven't been even detained yet. This is just an officer coming up to you. And the officer would have to tell you that you're detained. One nice thing about being pulled over is that they have to pop the lights, so you're being detained because they pop the lights. If you're walking around the street and an officer comes up to you and says, "Hey, I need to talk to you right now," you don't know if you're being detained or not. And there's actually, so this goes back to the wishy-washy standard sometimes, it's kind of a case-by-case basis. The legal standard for whether or not you're detained is, do you feel like you're free to go? Or is it reasonable for you in those circumstances to feel like you're free to go? And if the answer is no, well, then you're detained, even if the officer didn't mean to detain you. And if the answer is yes, then you're not detained. And that usually ends up being a very intensive fact-based inquiry that sort of is a case-by-case thing. But since you're asking about an officer just running up to you and talking to you, you don't have any obligation to answer them. You haven't even been detained yet. But if you think you have something to add about, "I'm just protesting," that's about the limit that I would do. I would not even associate myself. The officer might say, "Who are you here with?" That would be a common follow-up question. "Do you have ID on you?" No, you're not under any obligation to do any of that. And I would not do any of that. And I was at these protests, so I know I wouldn't do any of that because I know if an officer came up to me, even for a benign interaction, I wouldn't participate. You're involved in a political event that the police determined prematurely to be an unlawful assembly. So if an officer had encountered me during that allegedly unlawful assembly, I would not assist them in anything, even before I had been detained or arrested. I hope that gets the point across clearly enough. Okay, phone stuff. This is good. So let me try to, I think I'm actually over time now. Is this like feed going to cut off or something? Or do I get to talk about this?
No, the feed won't cut off. We got people here. We haven't lost anyone. Thanks for sticking with us.
Well, thanks for listening to me drone on.
This is fascinating.
Okay, so this is a really important issue because phones are ubiquitous now, and we have so much information on our phones. In fact, I think everybody in America would be terrified if some stranger got a hold of their phone and their unlock code and had unfettered access to their email, their internet, their text messaging, their contacts, all of it. So the Supreme Court has determined, this is a case from 1979, but I think it applies today, that metadata, the acquisition of metadata, is not a violation of your right to privacy. Metadata would be like the numbers on your phone bill. It would be like the information on when a photo was taken, the date and location of the photo, things like that. Most of the time, the police accomplish this by just subpoenaing your phone company and saying, give me all of Robert Baer's phone records. And then the phone company does it. And if I protested that and said, hey, that's a violation of my right to privacy, my Fourth Amendment right, I would lose on that, because my phone bill just has the duration of the call, the number I called, and the date of the call. And that's not private correspondence. Now, it's something different when you're talking about text message content. And the reason I mentioned text messages here is because this actually came up in a case I had a few years ago. And I looked into what the text message storage responsibilities are for phone companies. And every single major phone company indicated that they don't keep their text messages for longer than 48 hours in terms of storage. And that's not enough time for a subpoena to go through and be valid and all this. So with regard to the text messages that you send through your phone carrier, that even if there wasn't a Fourth Amendment right, I don't think those messages are really stored by the carrier anyway. That being said, that content, I believe, would be a violation of your right to privacy, because if you're telling your significant other, I love you, that you have an expectation, a reasonable expectation of privacy with regard to the content of that message. And that's obviously different than metadata on when you called that person and how long that you actually talked for. So I think there's both a Fourth Amendment problem with it, but I want to emphasize that even if there wasn't a Fourth Amendment issue, I don't think that the phone companies are actually storing the text messages. However, third-party apps like WhatsApp, Discord, there's others out there where it's like an app you download and it lets you do text message-like activity through Wi-Fi or through the internet. They're not under, I don't think that they delete the way that the phone companies do, or at least I guess what I'm going to say to protect myself here is I haven't looked into it with regard to those entities. So it's possible that WhatsApp could have some giant database of all the messages that you've ever sent to them ever, and that could be subject to a subpoena, and then there would be a Fourth Amendment implication. But Verizon, AT&T, formerly Sprint, now T-Mobile, they don't store those.
You could even
Okay, now
even something like iMessage, because iMessage, if you are an Apple user, does store your text messages. Like, let's say you use iMessage on your computer, they're stored in there indefinitely until you find and delete them.
Oh yeah, but that's true. And also iCloud is the other obvious example, where when you have any content on iCloud, that is on Apple's servers. So theoretically, Apple would have access to that content because anything that's stored in the cloud is on some server somewhere out in the world. So there are obvious exceptions to that where that would apply.
I do have a question for you on Signal, because a lot of people are using Signal right now to communicate as they're going through protest or engaging in various political activity. Do you have any opinions on whether it's really secure, or have heard anything about the legalities around using Signal?
No, I don't. I don't want to say, especially with people, I don't want to say anything that could end up being incorrect. I don't have any opinion on whether or not it's secure, and I don't have any opinion or not on whether it's trustworthy. But it does remind me, though, to remind the people listening to this that, and I'm not trying to make this sound like I'm trying to coach you guys all into how to get away with crime, but when you communicate with somebody, the communication exists on your phone and it exists on theirs. And so if the police are able to get to that other person and say, hey, did you talk to Robert? Yes. Did you text with them? Oh yeah, sure. Here's what we said. And then they provide the communications. You also cannot say that it was a violation of your privacy for the person you were communicating with to provide their copy of the communications to the police or any other governmental entity. It's just not a violation of the right to privacy because you hold the privilege of your communications and they hold the privilege of their communications, and that's that. So in terms of something like Signal, then that's something to think about. And beyond that, I shouldn't comment on it. All right, and the phone unlocking thing, this is just, I hope this is interesting for you because as an attorney, it's interesting for me, but sometimes I worry that I'm so far down the rabbit hole, things that are interesting to me just have other people's eyes glazing over. Can the police, if they arrest you, say they catch you red-handed robbing a bank, and you've got your phone on you, and they seize your phone as part of the arrest, and they're like, all right, we got your phone now, unlock it. And you say, no way am I doing that. You're going to find out how I planned this robbery or whatever. Can the police compel you to unlock the phone and then charge you with the crime if you don't? The answer is, I don't freaking know, because every court who has looked at this has come out to a different decision. And I talked about this on my show in June. And at the time that I talked about it, the Indiana Supreme Court had just come down with a decision that said, no, the police cannot make you unlock your phone. That doing that is a violation of your right to not self-incriminate. That's the whole point of the right to remain silent, is that you have a right to not self-incriminate yourself, or a right to not incriminate yourself. So is unlocking a phone that may have implicating content on it about the crime that you're being arrested for, is that implicating yourself? The Indiana Supreme Court looked at it and said, yes, absolutely, it totally is. And then as I was getting ready, the notes ready for this show, I looked to see if there were any new developments. And sure enough, literally yesterday, today's Tuesday, so Monday, or Wednesday, so it was Tuesday, the New Jersey Supreme Court said, yes, the police can actually force you to unlock your phone, and it's not a violation of your Fifth Amendment rights implication. So if you are committing a crime in the state of New Jersey, the police can force you to unlock your phone. If you then get out on bail and go commit a crime in the state of Indiana, the police cannot force you to unlock your phone. And federal courts have looked into this as well and come to equally disjointed decisions. Ultimately, and I expect it to happen within the next 5 years, the United States Supreme Court is going to have to weigh in on this and figure it out. And I have no idea what they're going to decide. So I'm sitting here as a lawyer who's supposed to be an expert on these topics, and I'm supposed to give advice to everyone. And I have trouble doing that here because the courts are very, very split on this issue. And it perfectly exemplifies the thing that I said at the beginning, which is the laws are can be in flux sometimes based on different circumstances or new technologies come out. And especially when you're talking about constitutional law, it's impressive on the one hand that the Constitution, which was written almost 250 years ago, has held up as well as it has to be applicable to today's problems. On the other hand, there are still questions where even the sharpest legal minds in a state have varying opinions. And this is one of the examples of that, where two, not insignificant states, New Jersey and Indiana, came to radically different opinions. And there are federal courts that have come to different opinions as well. So listen to my show every week. And as soon as the Supreme Court weighs in on it, I'll let everybody know what the final ruling is. But as of right now, and there is no ruling for California, by the way. So if you wonder what the law is for the state of California, don't have one. So it's an unresolved question as to whether or not the police can force you to unlock your phone if they arrest you. Okay, we're getting, I hope, pretty close. When can the police search you? Well, while you're being detained, they can't search you unless it's consented to. And in one interesting, they can do a pat down just to check for weapons, but not like a thorough search. But in one case, there was an interesting case where a guy was detained and he had a backpack, and the officer did not open the backpack, but like felt it from the outside, and then felt like a brick, and then opened up the backpack and it was like a pound of cocaine or something. The Supreme Court actually threw that out and said that was an illegal search, because feeling the outside of the bag still counted as a search. You don't actually have to open the bag for it to be searched. Now, what about when you're arrested? Well, when you're arrested, it's different. The police can do, their rights expand greatly. And if you have a bag, if you have a locked bag, they can open it. If you have a locked suitcase, they can crack it open, whatever's in there. If it's unrelated to the thing you're being arrested for, doesn't matter. If you have a severed head in a bag and you're arrested for petty larceny, then the police can open the bag, find the severed head, and now charge you with murder. The other thing is, as it relates to vehicles, if you're arrested, this is a sort of an interesting quirk in the law. The police can search the passenger areas of your vehicle. So they can search the driver's side, the passenger side, the back seat, they can do all that. What they cannot search is the trunk. Can't search the trunk. So, well, that's a weird quirk of the law, but that's there. Now, what they can do if you're pulled over and arrested on the side of the road is they can impound your vehicle because they can't just leave it there on the side of the road. And then as part of the impounding process, they can do what's called an inventory search, and then they can get into the trunk. So to give you an idea about how nuanced these laws can be sometimes, if you're arrested in a car, but the car is parked in a friend's driveway, the police can't access the trunk. But they can access everywhere else. If you're pulled over and arrested on the side of the freeway or on a public street, and the police say, well, now we're impounding the car, they can still search that passenger area, but now they can actually get into the trunk too, because they're going to take the vehicle to the impound yard. So a weird quirk in the law, but it exists.
Robert, we have a question from Denise. She asks, what about your glove compartment? Do you have to leave that unlocked?
No. So thank you for asking this question, because it is part of the thing that I just talked about, or it's part of the scope of what the police can have access to. When you're arrested, let's say you locked your glove compartment. Well, hold on. Let me tell you, first of all, you have no legal obligation to lock or unlock your glove box when the police pull you over. You can lock it, you can unlock it. If they pull you over and you end up getting arrested for something and your glove box happens to be locked, the police are within their rights to forcibly open it. And if they forcibly open it and there's a gun in there or something, well, you're going to get charged with that. And you cannot say you violated my Fourth Amendment right because you went in this locked glove box, even though that had nothing to do with what you arrested me for. You can't do that. So the glove box is in the passenger area. They have the right to go into the passenger area. That includes the glove box. It includes the glove box, even if the glove box is locked. So that's the definitive answer. Before you're arrested, though, if the police ask you during a Terry stop, let's say, hey, I pulled you over for a broken tail light. Would you mind opening your glove box and giving me your license and registration? You're not obligated to open your glove box. You're just not. You are obligated to give the officer your license and registration. If you have to open the glove box to do that, well, then you have to open your glove box. But if you keep your illegal drugs in your glove box, then keep your registration and driver's license somewhere else. Because when the officer says, open your glove box to give me your registration, just reach into your passenger seat or door panel or whatever, and give them the registration that way. When you're detained, you're under no obligation to do anything.
We have another follow-up on that. So the question is from Stephanie. So they can't search the trunk at all without a warrant, or can they make you open it if they suspect something? And Lisette says, what if, hypothetically speaking, my gun is in the trunk? Am I good?
Yeah. It's funny. The Fourth Amendment stuff always brings out all the hypotheticals. So as it relates to a trunk, the police have to have their own probable cause to go into the trunk. So if the police arrest you and they go around to the side of the trunk and there's a trail of blood trickling out from underneath it, that's good enough for them to pop the trunk themselves. They won't ask you to do it. They'll just take a crowbar and open it up and to see what's in there. And if it turns out that the blood was food coloring, oops, but they're under qualified immunity. There are no consequences for them being wrong about it. However, if another example would be you're driving like an old Celica or something like that, and the trunk is barely off the ground, and it looks like there's something like really significant in there. Courts have come out differently on this. Sometimes an officer will say, I smelled so much pot coming from that trunk. There was no way that whatever was in there wasn't marijuana. And then they'll use that as probable cause to pop the trunk to see what's in there. And if they're wrong, qualified immunity. But courts can come down differently. And if there's no specific articulable reason why they should be opening the trunk, they can't open the trunk. So the questioner's question was, I'm keeping my gun in my trunk, so am I good? Well, where's the car parked when you're arrested? Because if the car is in your friend's driveway or otherwise on private property, then the police cannot impound it. And since they cannot impound it, they cannot open the trunk. They have no reason to go into the trunk. However, if this all happened during you being pulled over on the freeway, well, now the police are going to impound your vehicle. And as part of the impound process, they are going to pop open that trunk and they're going to take an inventory of everything that's in there, including your gun. So I'm sorry to have to be so nuanced when I describe this. I wish I could just give you some black letter law for you to just sink into your brain and just know that you're good for the rest of your life. But unfortunately, with attorneys, I have to say it depends all the damn time. And this is one of those times. If the car is part of an inventory search because it's been impounded, they're going to find your gun in the trunk. If it's not, and it was on private property, and there's no blood coming out of the trunk or other independent basis to give the cops reason to open it, then they could not legally open the trunk. And if they did, since you guys probably wonder, well, what happens if they did it anyway and they just opened up the trunk and then found a gun and charged me with that? Well, you file what's called a motion to suppress in court and you argue it in front of the judge. And if the judge is doing his or her job, he'll say that the opening of the trunk was illegal and that the product of that search, the gun, was illegal, and that evidence cannot be used against you in any crime. And not only will your case probably be dismissed as it relates to the gun in the trunk, but they have to give the gun back to you as well. So
there's another follow-up on what about SUVs and station wagons? Are those fair game since the trunk is sort of connected to the car?
Man, that is a really good question. So I yes, that would, especially my wife drives we put the seats down, and so okay, I apologize for not having an answer at the ready for this, but the answer that I'm going to give you that I feel confident is correct is that those areas of SUVs, like the back where you would normally put the groceries or whatever, that those would constitute the passenger area, and that those would be valid to search, as long as there's this other concept in the law called plain sight that matters as well, which is if the officer can, without actually even going in the vehicle, it can just look through a window and see illegal contraband, then they can procure that contraband. So we've been talking about this mythical gun that was in a trunk. Well, if the gun is in the back of your SUV and the officer just sees it laying there in the very back through a window, well, he can obviously get that gun under the plain sight doctrine. Maybe the more interesting question would be sometimes like you can put the seats down and then maybe there's like a little compartment area. Maybe your gun is kind of tucked in there. Could the police search that? I'm sorry, I don't actually know. I just came up with a hypothetical to trick myself, and I successfully did so, because in that example where you would put the seats down and kind of tuck the gun into a side area where it's not plainly visible, but it's not exactly in a trunk. If you got arrested and the officers went through there and then found that gun, would that be a legal procurement of the gun? I don't know. And I don't want to say and be wrong and then have you guys all sue me for malpractice or something for getting that wrong. So sorry, I'll look it up and get back to you.
Thank you for answering those. You're getting a lot of thanks.
All right. So I'll go through these other ones since apparently time is not a factor anymore. Just to throw the clock out the window. Dog searches I talked about a little bit earlier, but I would encourage everybody to watch this pretty compelling 20-minute documentary on YouTube that's called Breakfast in Collinsville. And the premise of that is that these two Star Trek nerds were leaving a Star Trek convention and doing this like 2-day drive back to Denver, wherever they were from. And it was like in Ohio, and they got to it's basically like a speed trap. And it's one of those areas you hear about these where the police use speeding tickets to kind of gin up revenue for these like sort of small towns that are just sort of pit stops on the way to bigger cities. And the officer detained these guys and then called a canine unit out and said that the canine unit smelled marijuana, even though there's actually no marijuana there. And it ended up resulting in a number of different lawsuits. And again, this documentary, and it's only about 20 minutes to watch, but it's an incredibly compelling watch and perfectly illustrates problems that I have with people being pulled over and with dog searches in general, and with this sort of conflict of interest that police have in effectuating the law in an equitable way. And it's just really entertaining because they're Star Trek nerds. They're Star Trek nerds that are being browbeaten by an officer for allegedly being potheads in the middle of nowhere in Ohio. So everybody go check that out, and it kind of gets into issues of what Terry stops are and all of it. But it's a really good primer on, and it's really accessible for non-lawyers for what can go wrong during a Terry stop. Okay, sobriety checkpoints. I only included this because I wanted to complain about them. The Supreme Court has said that they're legal. They might be a good idea in terms of cutting down on DUIs. I actually think that that's not true. There's evidence out there that sobriety checkpoints don't prevent DUIs, but it's, in my opinion, a gross violation of, it's just police state activity. You're just driving around and the police have the right to put up a stop and then just sort of look at everybody as they drive through. I don't like it as a theoretical issue. The police, by the way, are supposed to advertise the sobriety checkpoints in advance of them actually being used. And in my experience, they choose the worst possible mediums to advertise. It's not the LA Times that they put these advertisements about sobriety checkpoints in. So sort of just nefarious conduct, and it's a waste of police resources, and it's not even that effective. And really, I just wanted to complain about it. So thank you for listening to that. All right, and then vehicle searches. Okay, we already talked about all that. So very good. Okay, warrants. Oh, great. We're sort of towards the end. So a warrant is a really powerful vehicle because that is the check on police. Everything that I've talked to you guys about up until now has been warrantless conduct. Either the police arrest you and they have the right to search you pursuant to that arrest, or you just communicate with them voluntarily, or they've detained you and they have more limited rights during that. But a warrant gives the police to do almost anything that they want that is within the scope of the warrant. And it's supposed to be checked by a judicial officer who kind of acts as a check on police and says, well, what are you guys doing here? And do you have good cause for it and all that? Warrants are a good idea. They go back to, that's specifically written into the Fourth Amendment, but there is still room for abuse. And, I didn't use the name here, but I wrote, warrants can obviously still lead to tragedy. And the Breonna Taylor case is the case that everybody should be thinking of, where that search was a legally correct search in the sense that it was approved by a warrant that was signed off by a judge. And in my opinion, for all the blowback that there has been about Breonna Taylor, and all of that is justified, there's been too little focus on the judge who signed off on the warrant. One article came out that said that the judge signed 5, or maybe it was like 10 warrants in a 5-minute period. And the implication of the article is that the judge wasn't actually reading the content of the warrant and doing what, I think it was a female judge, what she should be doing in verifying the validity of the scope of the warrant that the police were seeking. But other than that one article, I don't think enough attention has been paid to what I would consider to be bad conduct on the judge's part in signing off on a warrant that I don't think there was probable cause to justify. And the judges are supposed to be there to act as a corrective to cavalier police officers who want to just go banging on doors and hauling people into jail and into handcuffs. So I will say, without all that being said, though, is that when there is a warrant that has been signed, it is very, very difficult, I will say almost impossible, to overcome that warrant if you're challenging it on Fourth Amendment grounds. Meaning that if you are claiming that your Fourth Amendment rights have been violated and the violation was part of something that a judge thought enough of to sign off on a warrant, that is given significant deference in the courts. Meaning that when you're challenging your arrest to the court and you're saying to the judge, this was a violation of my Fourth Amendment rights. And the judge said, well, wait, wasn't there a warrant in this case? If you say, yes, judge, there was a warrant, but let me tell you about that warrant. It was totally improper. And the judge from the bench, and I have personal experience with this, is 90%, 99% against you from that moment. Judges give extreme deference to other judges. And one of the biggest challenges that exists in the law would be to get a judge in a criminal trial to open their mind enough to the possibility that the other judge who signed off on the warrant, because obviously it's got to be two different judges, one to sign the warrant and then one to hear the trial for the crime, that the first judge who signed the warrant might have made a mistake in that warrant. It is very, very, very difficult. I cannot emphasize how difficult it is to get the second judge, the trial judge, to consider the possibility that the first judge might have been in error. And this exists in all facets of the law, that judges give extreme deference to other judges. And it's like, well, hey man, if this other judge dealt with that problem, I don't care what the merits of the problem were. I'm just looking at the conclusion. And if the conclusion was that judge issued a warrant, or that judge issued a restraining order, or that judge made a determination, and that determination is relevant in this case, I'm going to assume that determination was made legitimately and expertly even. So that's the challenge there. The Breonna Taylor warrant, I think, was a completely bogus warrant, hasn't been covered enough by the media, and warrants are a good thing, but who's watching the watchers? and the judges are supposed to be watching the police, and somebody needs to make sure that the judges are doing what they're supposed to be doing also in vetting these warrants. And with that, Fiend.
Yeah, there's a comment here that says, Denise says, just like on Law and Order, where the cops choose the judges they think will sign the warrant that they want.
Yeah, and it's weird. Yeah, and it doesn't happen so much in LA because LA is such a big town. The judges cycle through a lot. It's actually been kind of a point of frustration for me as an attorney, is that you don't get as much of a rapport with judges as you would, say, if you practiced in Topeka or something like that, where there's one judge for the whole county. But in smaller jurisdictions, Law and Order is in New York, so it really wouldn't apply there either. But in smaller jurisdictions, yeah, there's this familiarity with the judge. Have you ever watched the show The Wire? If any of you guys watch The Wire, in season 1, the judge in that case is on a first name basis with both the DA and the cop in that case, and they'll go visit him at his house to sign a warrant. He's at a baseball game signing warrants or whatever. That happens commonly, and yeah, it's a cause for concern for me. And there are things to kind of be on the lookout for in First Amendment and Fourth Amendment jurisprudence. I think I covered a lot of them in this lecture, but one of them that's absolutely not covered enough is, are judges legitimately scrutinizing warrants the way that they should be? And are they a little too chummy with the people who are coming to them with those warrants in the first place?
There is a comment from Lizette. This goes back to gun laws. Earlier, she was saying California gun laws are so weird in her opinion. She says, I've been wanting to invest in one for protection as a brown woman, but then I've come to find so many restrictions / gun laws in California. I understand the gun safety reasons, but it feels unfair that cops are allowed to have them freely and not us civilians. I don't feel safe.
Yeah, it's hard to give legal advice on that because California is one of the more restrictive states to get guns. And just as a 30-second anecdote, I had a client whose husband was arrested for domestic violence. And in the course of that arrest, they confiscated all the guns from the house. What the police didn't know was that the guns were actually my client's guns, the wife's guns. And it took me, this is not an exaggeration, a calendar year to get those guns back from the police that were her guns that were improperly taken pursuant to his arrest. It was an incredibly difficult endeavor. In terms of registering a gun, I sympathize with it. I don't think that anytime soon the police are going to be disarmed, and you have a Second Amendment right to bear arms as sanctified by the Supreme Court about 12 years ago. But let me say this. There were about 10 cases, including I think 5 from California alone, that were petitioned to go to the Supreme Court this year. And everybody thought that the Supreme Court was going to take those cases because it was about time to weigh in on gun laws for the first time since 2008. And the Supreme Court declined to do so. And it looks like it was a politically motivated decision because the conservatives on the court who would like to expand gun rights were afraid that Chief Justice Roberts, who's become the swing vote now, wasn't going to side with them. And they didn't want to have the cases come to the court only to have the court rule against what the conservatives wanted. So I'm sorry to give you cold comfort here, but I don't think that the laws, at least as verified by the Supreme Court, are going to be changed anytime soon.
Do we have any other final questions on the First or the Fourth Amendment?
Hey, or the Second Amendment, just throw them out there.
Yeah, right. What about the Fifth?
Oh, so I think somebody asked something.
Yeah. Oh, they were asking about the Fifth in regards to your phone searches, because you were saying how the courts are like on the fence about this, but how does the Fifth Amendment not come into that? Like, she's asking where can we watch the recording? Again, on Facebook, on the KLBP Facebook page. Maybe Ashley, you could throw a link in the chat.
Yes, I'll throw it on there. It's the
well. But yeah, Robert, the question was about the Fifth, like, doesn't the Fifth Amendment apply for the phone searches?
Yeah, so that's the argument. And there's a really good, there are very good specific examples, and in case law is replete with these examples as to attempts to show conduct that implicates the Fifth Amendment. And what I mean by that is, this is sort of an interesting example, but the police, after arresting a person that they suspected of a DUI, randomly asked him what his birthday was without reading him his Miranda rights. And the police later on said, that's not an interrogation, because we weren't asking him to implicate himself in any crime. We were just asking him what his birthday is. And believe it or not, the Supreme Court said, yeah, but you were only asking him what his birthday was because you thought he was so drunk that he wouldn't know. And I think actually it turned out he didn't know. So the police actually invalidated that answer and said that the content, his failure to know what his birthday was can't be used against him in court, even though that seems like a benign question that has nothing to do with implication. And although that seems like it wouldn't apply to all, what does that have to do with cell phone unlocks? It actually kind of does, because the argument is being made by the police officers anyway. We're asking you to unlock your phone. We're not asking you to admit to a crime. We're just asking you to give us a digit to give us access to information. If we subpoenaed your tax records or asked you to produce those, you would have to do that. You have to produce documents. So what's wrong with just asking you to unlock your phone? And the Indiana Supreme Court said, well, that's sort of a gesture, that it's like if you ask somebody to nod instead of saying yes, the actual act of putting in the digits, if you know that there's implicating material on the phone. And I should say, actually, to illustrate the example, in the Indiana case, that was a case where a woman had falsely accused a person of rape, pretty serious accusation. And that person was arrested. The police eventually found out that she had faked the claim, and then they arrested her and then wanted to get evidence, probably text message evidence, off of her phone to help prove the charge of a false rape allegation. And then she refused to provide the number. So almost certainly in the Indiana case, there actually was implicating information on the phone. The New Jersey case, I'm not as sure about, because that decision just came out yesterday. So I haven't read the actual opinion yet. But if the circumstances were different, you might see the New Jersey court coming to a different conclusion as to whether or not you're implicating yourself by giving the 4-digit code to your phone. But anyway, the crux of the dispute and that whole thing with phones is, are you implicating yourself by just giving the number there? If you know that, and the argument is, if you know that there's implicating material on your phone, then just giving them access to the phone is kind of giving them the material. But maybe not. Maybe a number is just a number. You're just giving them the 4-digit number, and it's up to them what they want to do with it. Courts are very evenly split on this.
Fascinating. That's something to watch out for.
Yeah.
Maybe next time we get to split this into two different sessions, because this sounds like we could go down definitely rabbit holes on both ends.
Yeah, sorry.
No, this is great, and we've held the majority of people. We have had all of you on for an hour and 45 minutes. Thank you. Are there any other final thoughts or questions? You're welcome to unmute yourself if you'd like, if you feel comfortable with that. Otherwise, our next Know Your Power series is called Know Your City.
Am I unmuted?
No, there you go. There you go, Denise. Go for it.
Uh-oh. What did I do?
I hear you. I can hear you.
Hear you.
Oh, Lord, I'm that old lady saying, can you hear me now?
Yes, we can hear you.
We can hear you, Denise.
What was up with my phone?
That's challenges.
Live TV.
I know.
Oh my goodness. I know y'all probably trying to talk to me and I can't hear it. Okay. I just wanted to say this has been awesome. I got out of work early just so I could hear all the information for the Boys and Girls Club. I had been out there, and I am so glad that I did, and I truly appreciate all this information, and I will definitely be following you guys if you should do this again. Again, many thanks to you all.
Thank you very much.
Thank you, Denise, and feel free to share the video with others if you think that, and this goes for everybody, if you feel like others would benefit from this information. And the question about the next one, will the next one be relevant to people outside of Long Beach? So the next one will be about, it could be because your city is probably run similar to ours. Most municipalities are. We will be going through basically the city structure. So just, what is the city manager? What does he do? What's a city council versus a commission? And so kind of looking visually at the structure of the city, and then going through a public meeting, one agenda item of a public meeting, so that we can kind of deconstruct the jargon. Because if you've ever seen or tried to watch a public meeting, your eyes start to gloss over with all the gobbledygook, as I call it. And so we will have a local journalist break it down for you. So I think that some of that legalese and jargon breakdown would be applicable to any other city, but we will be using Long Beach as a specific example for that. And hopefully future sessions will go into detail on how to file a Public Records Act request. How can you actually hold your government accountable? Carlos is asking, are episodes of Bear Law available to listen to on demand like a podcast? This is super interesting. I'd love to know more. Ashley?
Robert, I don't think you don't have them up yet, right?
Yeah. So had I planned this out better, actually, this event would have synergized perfectly with the relaunching of my website to be launched imminently. So the answer to that is I have recordings of all the episodes, including episodes, by the way, where I actually talk about, I did an entire 2 hours on just the First Amendment and all these interesting cases I didn't have time to go through in this thing. So all of that is archived, and I'm going to publish it as a podcast with the relaunch of my website, and that should be done, let's say within a week or two. Let's say I'm now committing myself.
I can help you within the next couple of days if you need me to.
Okay.
I'm volunteering for that.
Now we have an even more aggressive timeline. Okay, so the answer is yes, soon.
You know what we can do is, for those of you that attended this one, Robert, when you have them up, we can email everybody who attended so that you guys are all alerted to when those are made available to you.
Good, that'd be great.
The beauty of a local low power FM station, right?
Well, I don't see any other questions, but I'm so grateful for the extra amount of time that you took, because I know there were a lot of questions and there's some dense topics to cover. So thank you.
No, I'm just glad people stayed. I was worried you don't want to lose your audience. So that was great. And thank you everyone for the questions and then giving me a chance to talk about this stuff. It's really near and dear to me, as I think you can see.